everyone. Welcome back. I'm Professor Liz Tippett at the University of Oregon School of Law.
And I'm Jessica Brown, a 3L here at the University of Oregon School of Law.
In this section, we'll continue our interview with Professor Leah Vandervelde,
as she speaks to us about the rise of cases that shed light on the modern non-compete.
Professor, I was really interested in your piece on gendered conflicts in employment law and how the law was used to enforce contracts, especially with female performers. Could you talk a little bit about that?
So I began gathering cases in the 19th century that would advance my study of Blackstone and Blackstone's subordinating nature in master and servant. And I read hundreds of cases involving men. And then, when I began looking at specific performance and negative specific performance, I began to see women litigants.
Specific performance is when a court orders somebody to do something. So they'll say, you must do this. And negative specific performance is when a court says, you may not do the following things. You may not work for the fidget spinner factory. And then usually what courts do, though, is award money damages. And so the people can do whatever they want. They just have to pay up the value of the contract.
It was shocking because women were not litigants in more than 1 out of 1,000 of the other cases.
Wow.
And in the 19th century, in this line of cases, they were all women. Every single case was an actress. In all of these cases, it seemed that they were performing artists who had particular and unique skills. And because they were unique, they were valued, I might say coveted, by the person who had put them on the stage. And if she's that good at getting competing offers, well, the natural notion of a person's skills rising to the level where they should be in the market should suggest that she should be able to quit.
Right.
And go to that other second employer.
Sure.
And serve that second employer, perhaps subject to damages, but certainly free to make those choices herself.
Right. Freedom of contract.
Freedom of contract.
But that's not how it turned out.
That's not what happened. Surprisingly, the women were losing. They lost in every case after one case that was decided during the Civil War.
These were cases with high-profile actresses who signed contracts with theaters to work for a specific amount of time. And what happens when the actresses decided they didn't want to work with the theaters is there was a breach of contract, and then what would follow would be a legal dispute over what the theater was owed from the breach.
Yes. In the next 11 cases decided in the same century, actress after actress after actress loses.
Why do you think that is?
I think that the reason is because women were seen as subject to a different status. And as women, the whole idea that they would be performing on the stage suggested that they should be subject to some greater social control.
Okay.
The greater social control should be that they should be loyal to their theater owner the way a wife is loyal to her husband.
As I was reading your paper, it made sense how the courts were treating women, given how society treated women back then. But then you started to talk about how the courts were treating these breach of contract cases like a divorce, and they were using faithfulness. And that's when it really hit me, like, oh, wow.
I think that the idea that one particular judge was both performing divorces in New York, which prevented complete divorces, and was the judge to whom these actresses' cases were being taken, suggests that he might have been thinking along those lines.
Yeah.
I do still think that, to some extent, that's how employers still think about it, like a divorce. I mean, not just you need to be faithful to us, but how they think about employees generally. I mean, they'll write contracts at the start of employment where they're really excited about them and they make a lot of promises, and then when they sour on the employee, they get super mad, like as if they're divorcing, and they just can't ever imagine a time that they like this employee. They're just like filled with anger and rage.
It does become interpersonal when it should be professional.
Thank you, Professor Vandervelde. We really appreciated the time and your expertise.
Yes, thank you very much for speaking with us. Yeah,
Thank
thank you.
This was a real pleasure.
That concludes part 3 of our interview with Professor Vandervelde.
Special thanks to Amber Lesher for helping with the interview, and of course to Professor Vandervelde for her time. If you want to check out the next episode of the series, be sure to subscribe.